Hello everyone, myself DHANUSH Kumar. I've been a civil services faculty for past 5 years. I have trained numerous students in various competitive exams. Now, in association with VIRAT Hindustan SANGHAM and UDAYA News Karnataka, we have launched a free crash course for competitive exams. This program is inspired by Dr. SWAMY. Hope you all know this great person of India who has contributed immensely for the service of Bharat Mata. So this program was started yesterday, that is 28th of January 2022. So you can watch the course online at the comfort of your home. So these are the channels. You can watch it online on YouTube channel of VIRAT Hindustan SANGHAM. This is the link. So you can just type VIRAT Hindustan SANGHAM on Google or your YouTube app. So you will get the channel and you can subscribe there and have access to this program on a daily basis. And you can also watch this program on UDAYA News Karnataka YouTube channel every day. So it will be uploaded every day by 5 p.m. And if you want to associate with us further, you can join our Telegram channel. This is the link. So you just type VHS Education on Telegram application. So you will get our Telegram app for free mentoring for all competitive exams. This program is being conducted by Sri Ravishankar ji, who has been the State Education Convener for VIRAT Hindustan SANGHAM Karnataka section and is also the President of Good Neighbors India non-governmental organization. So has been associated with various welfare programs for the benefit of poor and lower sections of the society and also for educating the poorer sections to attain greater rights in their career. So I am the chief mentor of your program. This is my picture. So yes, let's move further. So as I told yesterday, this is a free crash course program. So this is a timetable. We are going to conduct Polity from 28th till 6th February. Later on history, economy, geography, environment, and the goal, there it goes. So what do you expect out of this course, classes, and how to make best use of this course for both veterans and freshers? For freshers, this will give you the entire picture of what you have to study in order to qualify the competitive exams. Competitive exams as in UPSC Civil Services, State Civil Services, SSC, banking exams, general awareness questions, as well as when you come to Karnataka specific exams, we have Group C exams, Sub-Inspector exams, FDAs, SDAs, and various other exams. This program is absolutely free. Now we are not charging anything. It is being conducted for the welfare of students in order to attain good job opportunities in their career. So you can also join our Telegram channel for further guidance. This is our channel and you can click on this QR code in order to join our channel. Okay, let's move further. So what am I going to do with respect to Indian polity? So first we are going to start with yesterday we did complete the origin, evolution and salient features of Indian Constitution. Today, that is 29th of January, we are going to deal with the most important aspect, that is fundamental rights, directive principles, and most probably also duties and basic structure. So let's move ahead and start the class. I welcome you all to this program. So starting with fundamental rights. What do you mean by fundamental rights? See, you have to decode the word first. Fundamental means which is basic. So, being born as Indian citizen, you are entitled to certain privileges. Rights means privileges. So, without performing any work or without adhering to any specific conditions, just qualifying the condition of being a citizen of India, you are entitled to this fundamental rights. So the question arises, are only the citizens of India entitled for these rights? No. Even aliens, that is foreigners, are also entitled to certain rights, not all rights. So we are going to see that in the due course of the class. So starting with fundamental rights. So what are the features of these fundamental rights? I told you these are very fundamental. As in, these are the basic rights which are available to you, qualifying the being a citizen of India. So this fundamental rights is in the part 3. So see, this part is very, very important. So direct questions can come out of this. So there are many times in AFCAT exam it was asked that in which part does the fundamental rights fall? It is in the part 3 of the Indian Constitution. So where did we borrow these fundamental rights from? So is it indigenous or have we taken it from some other constitution? So we have taken it from Bill of Rights. Where is this Bill of Rights? It's in the USA Constitution, United States of America Constitution, one of the oldest constitution in the world. So we have taken it from there. So we have rights starting from Article 14 till Article 32. So before moving ahead, so we will discuss some features. So are they absolute? No, they are not absolute. They are subject to certain restrictions. So for example, when it comes to liberty, is your liberty unlimited? No. Your liberty is limited by certain checks and balances, wherein your liberty doesn't hamper the public order or social morality. So your liberty should not be a threat to liberty of some other person. That is why there are certain checks and balances. Okay. So most of these fundamental rights are available against the action, arbitrary action of the state. So state cannot deprive you of your fundamental rights. Some of them are negative in character, that is, they prohibit you from doing certain things, whereas certain others allow you to do certain things like freedom of expression. You are allowed to express yourself freely. So they are not permanent. So some of them are permanent by the way of basic structure. However, the parliament can amend the constitution and the fundamental rights. So also during the emergency, these fundamental rights can be suspended. So they can suspend the fundamental rights during emergency. And also there are certain other conditions to which the fundamental rights are subjected to. So next, what is Article 12? See, we speak of the term called state. What is this term state? Is it the state governments we are speaking about? No. So state includes, as per the Article 12 in part 3 of the Constitution, the term state, S-T-A-T-E, big S. It includes the government of India and the government of states. It includes the legislatures. It includes the judiciary. Does it include the judiciary? No. State, the term state doesn't include judiciary. So, local authorities are included. That is, municipalities, panchayats are also included. Along with this, PSUs, that is, what is PSU? Public sector undertakings. They are also included within the definition of the state. So, all these organs fall under the definition of the state. Okay. So, next comes the life-giving provision of the Constitution, which gives effect to all these rights. What is that? Article 13. What does Article 13 say? It says, sorry, all that laws, 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 whatever laws are being formulated by the Parliament, if it is inconsistent with the fundamental rights, then those laws stands void. For example, I'll give you an example. So, independence of judiciary or else right to life. So, if the government passes a law which takes away the right to life, so such a law is void. It cannot be implemented. So, that is what is meant by Article 13. Whatever laws are not inconsistent, whatever laws are inconsistent with respect to fundamental rights, they stand void. They cannot be enforced by the government. So, moving ahead, so citizens and foreigners' rights. So, what are the rights which are available to citizens of India and what are the rights which are available to foreigners? We have to look in detail. So, when it comes to foreigners, prohibition on the discrimination on the grounds of race, caste, sex, place of birth. So, this is available only to citizens. Foreigners cannot exercise these rights. They can be discriminated based on their place of birth. So, in matter of public employment only Indians can access to, not the foreigners. Foreigners cannot access Indian government. They cannot become IAS or IPS. So, freedom of, that is Article 19, freedom of expression. Foreigners are not entitled to this right. So, along with this, freedom of language and also protection of minorities, that is Article 30 is not available to foreigners. What are the rights which are available to foreigners then? So, equality before law, that is Article 14 is available to foreigners, and also in respect to conviction of offences, you do some crime and you get convicted. So, you have certain provisions, that is freedom from prosecution for double jeopardy. Double jeopardy, we will discuss it when it comes to that section. Article 20, that is available to foreigners. Protection of life is available to foreigners. And also, right against arbitrary detention, that is Article 22, preventive detention, that is also available to foreigners. Along with that, prohibition of employment of children in hazardous work and human trafficking, that is also available. And also, freedom of religion, Article 25 is also available. So, these are the certain rights which are available to foreigners. So, moving further, we will dwell deep into we will start with the fundamental rights. The most important right is right to equality. Sorry. Okay. So, black looks somewhat scary. So, I want to change the color. How do I do it? Okay. Okay. Let me not do anything nuisance. So, let it be. Okay. So right to equality, which starts from Article 14 to Article 18, very, very important, though very simple, very important. First we have equality before law and equal protections of laws. What is equality before law? This concept is derived from Britain, British origin. What does it say? So, any special privileges for in favor of any particular section. In Britain, during feudalism, we had these serfs, we had these knights, and we had these lords, and everyone who had special privileges. Whereas equality before law says there is no such privilege, absence of such privilege, and everybody is equal. The second, what does the second? Equal subjection of all persons. So, if there is a law of land, what is the law of land? In India, it is Indian Constitution. Everybody is equally subjected to the law of the land. That is the second provision. So, no person is above law is the third provision. Whether poor or rich, high or low, everybody is equal. That is the third provision. The second concept, this is very important, equal protection of laws. What is equal protection of laws? So, equal treatment under equal circumstances. So, equal treatment under equal circumstances. If a poor person kills someone and a rich person also kills someone, both are equally liable for prosecution. So, no special treatment. So, if the treatment is given, good treatment is given to someone, it is also given, everybody else is also eligible for such treatment. So, this action is with respect to state, not private entities. So, similar application of laws to all persons who are similarly situated. This is the origin of your reservation. So, equality doesn't mean that there is no reservation. So, those who deserve, equally situated. So, the socially backward people they as a section are equally situated. Socially advanced people they as a section are equally situated. So, when all of them are equally treated, it is not equality, it is inequality. Whereas equally situated, the lower section are treated as a chunk, as one, they are treated equally by the provision of reservation, and the upper section are treated as one, as a section. So, then comes the concept of equity. So, when those who are equally situated are treated equally, it is called the concept of equity. It as the element of social justice. So, where does this concept takes its origin from? So, it takes its origin from rule of law. Where did the rule of law originate? It again originates in the Britain. So, in Britain, what does the rule of law says? Absence of arbitrary power to the government. There is no arbitrary power for the government. So, equality before law and equal protection of laws. Equal protection of laws. What does equal protection of laws means? What I just discussed. So, poor or rich are equally treated, and also those who are similarly situated are treated similarly. Similarly, I explained what is the meaning of similar situation, those who are similarly situated. Okay, what are the exceptions to equality? What are the exceptions to equality? There are certain special privileges for the president and governors of the states, and they cannot be liable for criminal prosecution during their tenure. During their tenure, the governors cannot be criminally prosecuted, and also no civil proceedings can be instituted against them except for giving 2 months advance notice. So, these are certain of the exceptions to right to equality. And no member of parliament is liable to give witness during the session. When the session is when the session is running, when the session is on, no person can be called by the court to give witness in front of the court. So they can seek an exception. So similarly, we have various other exceptions like Article 105. What does it say? What does that say? So no member in the parliament. Parliament has so many members, legislators. If they say something in the parliament which is against law or give certain vote in favor or against, they cannot be held liable by any court. So that is one of the exception to right to equality. So there are some other exceptions which you can look into the standard books. Coming to the next right to equality, which is prohibition of discrimination on certain grounds. What are the grounds? What are the grounds? So the grounds are 5: religion, race, caste, sex, and place of birth. So these are the 5 grounds. Based on these, so it says that under these 5 circumstances, there cannot be prohibition, there cannot be any discrimination. However, can there be discrimination on other grounds? Yes. Apart from these 5 grounds, that is race, religion, caste, sex, and place of birth, there can be discrimination on other grounds. We will see what are the other grounds. Sorry. So here the state is, so I said there are certain exceptions. What are the exceptions? The state means, I said Article 12. There are various meanings for the state. The state can make certain provisions for the education of the children of its particular region. The state is permitted to make any special provision for women and children. If the state makes special provisions like right to education, free education, or giving nutritional support to women and various other things. So their prohibition, so it can be limited to certain specific sections. So males cannot access to these particular programs. So their discrimination is valid. And also state can make special provisions for advancement of socially and backward situated people. That is what? The scheduled caste, scheduled tribes, other backward castes. The state can make special provisions for them. Special provisions as in reservation in education, reservation in jobs, waiver of fees, providing scholarships, various other things. So they can provide, the state can provide special provisions for these particular sections. So even your reservation of OBC reservation in education institutions, and even the recent EWS reservation. What is EWS? Economically and weaker sections, economic and weaker sections. So if, what was the amendment by the Constitution? 103 Amendment Act. 103 Amendment Act says EWS can get reservation in education and job. In both these, EWS has access for reservation. So is it available in the state governments? It is not yet available in the state governments. Only the center has done it. So maybe certain states have done it, but not the state of Karnataka. Okay. So coming to the next right. So in reservation also there are certain criterions. Yeah, that is, one criteria is your creamy layer. If you are income is above specified amount. The specified amount right now is 8 lakh per annum. If your income is above that, and also if you own any immovable property over certain specified limit, then your reservation is not applicable. You are treated as a general merit. That is the criterion. Okay, next right is article. So this is your article 14, 15 and 16. Article 16, equality of opportunity in public employment. Public employment means what? Your state civil services, central civil services, so hiring by various public sector undertakings, that may be your banks, public sector banks, or even your ONGC Videsh Limited, oil, NTPC. So all these constitute public employment. So here there can be no discrimination only on religion, race, caste, sex, descent, place of birth or residence. Two other criterions are added to Article 15. Article 15 said what? Race, religion, caste, sex and place of birth. Those are the 5 criterions. However, here another 2 criterions are descent. Descent means what? From where you have come. Whether you have come from within India or outside India. And also the second thing is residence, whether you are resident in a particular region. That is also matters here. So here there are certain exceptions. As every every fundamental rights has exceptions, this also has exceptions. What are the exceptions? State can prescribe residence in public employment for certain public employments. Certain public employments, the state means, as I said earlier, state government, central government, executive, legislature, PSUs. So all these come under state. They can prescribe residence as a mandatory condition. Though, and also the state can provide for reservation for the socially and economically backward, educationally backward section, not economic. So now economy is also valid under EWS. So these are some of the exceptions. Next comes the question of Mandal Commission. EWS I have discussed, it is 103rd Constitutional Amendment Act. So a bill, what is the bill of EWS? A bill is different from an act. So a bill is which is introduced in the parliament or state legislature, either in lower house or upper house. So before enactment of the bill, that is signing by the governor or the president, if the bill is in a stage of enactment, then the bill is called as, then that particular instrument is called as bill. So once the president or the governor at the central or state level assents, that is signs the particular instrument, then it becomes an act. So this is the difference between bill and act. So EWS 103rd Constitutional Amendment. So is it 103rd Constitutional Amendment or 104th? What is the constitutional amendment for EWS? It is 103rd Constitutional Amendment Act. What is the bill? It is 127 Constitutional Amendment Bill. So the bill number is different from act number. Okay. Next comes the question of Mandal Commission. What is this Mandal Commission? When was it constituted? So it was constituted in the 1970s, later part of 1970s, around 1978 by Morarji Desai government for giving reservation for the other backward caste or classes. So It's not other backward caste, it is other backward class, because it's a socially and educational concept, not an economic concept. However, later economic concept was introduced by Supreme Court under the concept of creamy layer. What is that case? Indra Sawhney case, 1992. Okay. Next comes in Mandal Commission. What did it do? So it provided 27% reservation for the OBCs, other backward classes. It said there are 52% of Indian population are OBCs, which deserve 27% of reservation. So today we have 7% of reservation for OBC, thanks to Mandal Commission. When was Mandal Commission implemented, under whose prime ministership? So it was implemented during the prime ministership of VP Singh in 1991 or 1990. Please check out. That is for you to check once. Okay. The year is not so important, however. So next comes the article number 17, abolition of untouchability. What is untouchability? It is a caste concept. So there are Chaturvarnas, Brahmana, Kshatriya, Vaishya, Shudra, and the fifth Varna is Panchamas, who are untouchables. So article 17. So this was a unique, peculiar concept. So this untouchability is a peculiar concept to India based on caste system. So it has its origins in the Purusha Suktas, Vedic times, Purusha Suktas. That is where we can see the origin of caste system. So there the caste system originated and it gave rise for untouchability for the Panchamas. That is the fifth section. They are also called as Chandalas by the upper caste. So this was constitutionally abolished by the Indian Constitutional Assembly, and they provided for untouchability. If you practice untouchability, there are certain prohibitions. Also we have, this was legally enforced by a statutory act, that is Prevention of Untouchability Act 1955, which was later renamed as Protection of Civil Rights Act, later renamed as Protection of Civil Rights Act 1955. Sorry. Okay. So next comes the question of abolition of titles. Earlier we used to have titles, I mean the Rajas. Rai Bahadur was one of the title. So except for military and academic titles, that is military title as in Captain, Major General, Lieutenant General. So these are certain Air Commodore. These are certain military titles. Whereas academic titles, what is academic titles? Professor, Doctor. These are certain academic titles. Apart from this, no other title can be given, like Maharaja, Raj Bahadur, Rai Bahadur, Rai Sahib, Diwan Bahadur. These are certain titles which are abolished by Article 18. So here the Article 14, 15, 16 are very, very important. Next comes right to freedom. Sorry. So right to freedom is what? There we have 5 rights, 19, 20, 21, 22. Sorry, 4 rights. So we have the first important right is Article 19. Protection of 6 rights. Freedom of speech and expression. That is where this press, Indian media, press and print and electronic media derive their freedom from. So nobody can touch the media because they are protected under Article 19, freedom of speech and expression. What are the 6 rights? So freedom of assembly, association, freedom of speech and expression is the first right. So I have not mentioned freedom of speech and expression here. So freedom of speech and expression is the first right. Next is, so you can speak whatever you want, you can express yourself in whatever way you want. However, there are certain restrictions. It is subject to public morality. Next comes, so as I said, the press and even your RTI holds its origin in freedom of speech and expression. Sorry. Next comes your freedom of assembly. Freedom of assembly. So you can assemble wherever you want, that is in the public places, peacefully, without any arms, without carrying any arms. Arm means machetes and other such arms, guns, so knives, all these things. If you carry such arms, you are liable for prosecution. However, when section 144, what is section 144? Curfew. So it is called as curfew in general parlance. When section 144 under CRPC, what is CRPC? Criminal Procedure Code. When was it enacted? 1973. When was Civil Procedure Code enacted? Enacted before the British left. So we are still, Civil Procedure Code is not yet amended. So Criminal Procedure Code 1973, section 144 is imposed, then you cannot peacefully assemble. Next comes freedom of association. So to right to form associations. What are the associations? Like companies, political parties, NGOs, organizations. All these can be cooperative societies. So even your cooperative societies come under this freedom of association. Next comes freedom of movement. You can travel anywhere within India. Anywhere within India you can travel, right? However, that is also subject to certain restrictions, that you cannot go to restricted areas like tribal areas and all, you cannot go and visit. So if you also want to visit 4 states, that is Arunachal Pradesh, Nagaland, Mizoram and Manipur, you need inner line permit, ILP, that is also there. It is in the interest of national security. Okay. Next comes your freedom of residence. You can reside anywhere you want within India. So this is the cause of origin for internal migration. So we see a lot of Bihar and Uttar Pradesh migrants and also migrants from Northeast India residing majorly in Maharashtra, Karnataka and Punjab, Haryana, Delhi and various other parts. So wherever you say sons of soil theory, that these people do not belong to that particular state, they are constitutionally protected, that they can, Indians, being an Indian, even the Northeast people can reside in any of the part of India. So they have constitutional protection of residence. Next comes your freedom of profession. You can practice any profession, however, legal profession, and you have to pay taxes timely. This does not entitle you to practice illegal professions like trafficking, prostitution and smuggling, trading in drugs, manufacturing of arms without license. All these things are prohibited. So next comes your protection in respect of conviction for offences. Suppose someone has committed an offence, so there he has certain protection granted by Constitution. Why this Constitution has granted such protection? Because during British times, what used to happen? There used to be arbitrary convictions based on the whims and fancies of the government. So there was no checks and balance on the government. That is why this was included in the Constitution. So what does it say? No ex post facto law. Suppose you commit a crime yesterday and there is a new law today. New law is enacted today. So you cannot be prosecuted under the new law because your crime is committed yesterday. So you have to be prosecuted under the old law itself. Next comes no double jeopardy. That means suppose you are committed a crime, then you cannot be prosecuted twice. You can be prosecuted only once for one crime. Next comes no self-incrimination. That is, you cannot be forced to give evidence against yourself. So you have right to remain silent. So this does not. So this also has certain exceptions. That is, when you are convicted under certain terrorist acts, that is UPA. UPA doesn't entitle you right to remain silent. Next comes your protection of life and personal liberty. That is, whether you take, that is your Article 21. So we have Hadiya case, Maneka case and Puttaswamy case. Right to privacy, which case? Puttaswamy judgment by Supreme Court. What does Maneka Gandhi case say? Right to life is a fundamental right, is again justified by the court. In Maneka Gandhi case, what does Hadiya case say? So the person has right to choose a life partner on their own if they are above legal marriageable age, that is 18 years. So in the Gopalan case, so Supreme Court, Gopalan case 1950, Supreme Court had taken a narrow view. Narrow view means, so right to life is available only against arbitrary executive action. Executive action means government cannot arbitrarily take away someone's life. You cannot do encounters. However, it is not applicable to arbitrary legislative action. However, by passing a law, government can take away someone's life. However, in case 1, Maneka Gandhi case said, no, it is available against both arbitrary legislative and executive actions. So earlier what used to happen, what was the terminology? Earlier we used to follow procedure established by law. Procedure established by law means, so arbitrary legislative action was allowed. So if legislative action allows encountering a criminal, then encountering can be done. However, post Maneka Gandhi case 1978, it is said that you cannot take away the right to life even by arbitrary legislative action. So that action should be justifiable. So the court has introduced procedure established by, due process of law. So due process of law means the law should be justifiable, reasonable. So earlier we used to follow Japanese model, that is procedure established by law was followed in Japan. However, due process of law is followed in USA. That is why United States of American Supreme Courts are, federal courts or the state courts are one of the most powerful courts in the world. Okay. Next comes your right to education. Does it have a specific right? So let us first discuss certain provisions under right to life. What are the provisions under right to life? Right to live with human dignity, right to sleep, right to remain silent, right to free legal aid, right to food, right to information. So your right to information also has origin here. Right to health, your Ayushman Bharat, right to privacy, right to livelihood, your Manrega, right to sleep, right to opportunity, so many other rights. This also forms a part of basic structure of the Constitution. So you can type your doubts, whatever you have, in the comment section. We will try to address it. Okay. Next comes right to education. Was it there in the original Constitution? No. Does it have a separate article for it? Partially, yes. It's that is Article 21A. It is under right to life only, but under a subsection A. So, right to education means what? So, earlier, so this was introduced when? During the year, right to education was introduced during the year 2002 by constitutional amendment. So, right to education says every person until the age of, from the age of 6 until the age of 14 has the right to access free and quality education. So 6 to 14 years is the time limit. They have to get free and quality education from the government. That is why this Sarva Shikshan Abhiyan, Samagra Shikshan Abhiyan. So that is why this midday meal scheme. So all this start from right to education. Even your 25% reservation in the RT Act. When does the RT Act was enacted? 2009. 25% reservation for sorry, 25% reservation in the private schools for weaker sections was enacted. So it comes under right to education. Okay. Next is your protection against arrest and detention. So we have Indian Constitution is one of the few constitutions which has made preventive detention. Preventive detention means what? So there are two kinds of detention. One is punitive detention, another is preventive detention. Punitive detention means you are detained, you are arrested only after you commit a crime. Once you commit a crime, then only you are arrested. However, preventive detention means you are prohibited from committing a crime. So all this Public Safety Act in Jammu and Kashmir, National Security Act, everything allows preventive detention for people who are over enthusiastic to cause disorder in the public, in the society. So they are arrested. So it has got two parts. The first part is right to protection against arbitrary detention against ordinary law. Under such law, you are entitled to be informed of the grounds of detention. So the police have to inform you why you are detained, and within 24 hours, if you are not produced before the magistrate, then you have to be released immediately, and you are entitled to be represented by a legal practitioner, that is a lawyer. Right to free legal aid. Free legal aid comes under Directive Principles of State Policy, Article 39A. Okay. Next comes in the case of preventive detention, by preventive detention laws, certain laws, as I said, UPA 1967 to prosecute terrorists. In such cases, the prevention cannot exceed 3 months. It cannot exceed 3 months. However, a board, expert board has to recommend further detention. This expert board, advisory board, is constituted by the judges. So judges have to allow your detention post 3 months, or else you have to be released. In this case also, you are entitled to be informed of the reason for detention, except in case of national security. Okay. So right to freedom is done. Moving further, we have right against exploitation, Article 23 and 24. So right against exploitation. What does this right against exploitation do? What does this right against exploitation do? So, first of all, it prohibits traffic in human beings and forced labor. What is human trafficking? This prostitution, selling of human organs, forced labor, beggar. What is forced labor? Earlier you used to have vishti and beggar, which are forms of forced labor. You take a debt from a local moneylender or zamindar, you don't repay the debt, you are forced into a labor for generations together. So, beggar. So, right against such forced labor is under Article 23, and also human being trafficking. So, international trafficking, domestic trafficking for prostitution and any other things. So, it also prohibits things like Devadasi system and also slavery. Slavery was made illegal in the 19th century, until which it was legal. Next comes your, so here under Article 23, we have under the provision of Article 23, various acts have been enacted. What are the acts? Minimum Wages Act, Bonded Labor Abolition Act, and various other acts have been enacted. Next we have prohibition of employment of children in factories. Children are protected from employment in factories. So, under what age? So, within 14 years, all children are prohibited from working except in family-based enterprise. However, from 14 to 18 years, only hazardous work is prohibited. Other employment is not prohibited. What is the law that enables this provision? So recently the government in 2016 enacted the Child Labour Prohibition and Regulation Act. Okay. That is the major act. So the years are important here. 14 years is the benchmark, and also 18 years, post which you will be an adult. So who is the person who has done a revolution with respect to protection of children rights, saving children from labor, child labor? It is Sri Kailash Satyarthi, who was awarded Nobel Prize. Okay, next comes your right to freedom of religion. So, what is one of the most important right in context of India, which gives force to the secularism provision of the what? Secular provision of the preamble. Okay. So, freedom of conscience and free profession, practice and propagation of religion. So, freedom of conscience. Conscience means what? So, you are allowed to decide for yourself what is good for you. You can think for yourself. You can freely profess whatever religion you want, and you can freely practice that religion without any threat, and you can propagate that religion. You can conduct seminars and programs to propagate that religion. However, it does have certain caveats. What are the caveats? So, it doesn't involve right to convert. So, the present issue is anti-conversion bill being debated in Uttar Pradesh and various other states. So, this propagation of religion doesn't entitle you to right to forcefully convert someone into your religion by advancing economic benefits or any other benefit. Okay. Next comes your right to manage religious affairs. Here comes the issue of Sabrimala and Haji Ali Dargah. So, you are So what does it say? What are the, you can manage your own religious affairs. That means you can establish institutions to manage religious affairs. You can you can own immovable or movable property in the name of religious institutions. So you can administer it according to your own religious laws, and these are the provisions under freedom to manage religious affairs. So here comes the issue of Sabrimala. So you can manage your own religious affairs, which entitled the religious organizations to prohibit women from accessing temple sanctum of Sabrimala. So Young Lawyers Association of Kerala filed a case in Supreme Court, and Supreme Court legally made it invalid to prohibit women from accessing sanctum of Sabrimala. So here comes the issue of ERP, essential religious practice. Where can you trace this origin to? Where did it evolve? Essential religious practice. Essential religious practice means what? Practices which are essential to a religion. Like, for example, performing namaz 5 times a day is essential for the religion of Islam. Likewise, Hinduism also has certain essential religious practice. The court questioned whether prohibiting women is an essential religious practice. So they took reference from Shirur Mutt case 1952. From there they took the reference and said that no, it is not an essential religious practice. Similarly, not allowing women to inside the Haji Ali Dargah was also said in void in the respect of constitutional equality, and said no, it is not a essential religious practice. Okay. Next comes your freedom from taxation for promotion of religion. So this is where all the black money in the religious institutions find its origin. So religious institutions need not pay any tax. They are exempt from paying any tax. However, they can be charged some fees for managing of some secular affairs, like conducting Vaishno Devi Yatra. So the government can charge certain fees to ensure security of the travelers. However, they cannot be taxed for that, carrying out that yatra. So earlier, during the Delhi Sultanate, there used to be jizya tax on Hindus to practice their own religion. So now that is not there. So next comes freedom from attending religious instruction. Article, which article? Article 28. So this in certain institutions, the children cannot be forced to attend religious instruction. So for example, earlier what used to happen before the independence, these Christian convents and missionary schools were forcing children to pray to their particular god against the provision of the child's religion. So without the permission of their parents. Now constitutionally you are allowed freedom from attending such religious instruction. So where all this is allowed? So institutions wholly maintained by the state. So state government, that is government school, you cannot give religious instruction. So religious instruction cannot be given in government school. Institutions administered by the state but established under any endowment or trust. There administered by the state there actually religious instruction is permitted. However, in the case of institutions recognized by state, institutions receiving aid by the state, so certain colleges, aided schools and colleges, so aided and institutions recognized by state, their religious instruction is permitted. However, the child's parents, or if he is an adult, or if he or she is adult, his or her consent is necessary to attend. Okay, this is all about freedom of religion. Next we move to cultural and educational rights. Article 29 and 30. Protection of interest of minorities. So, all the communal chaos which was there pre-independence. So, when did communalism start in India? Is it a historical fact or a creation of British? So, it is said that since ancient times, since the arrival of Islam in India, the communal incidents were not so stark. So, though it was there, it was not so stark. However, only after the 1857 War of Independence, so then the British started using Muslims as baits. So they used them against Hindus to promote their own interest, which resulted in spread of communalism, which ended in the division of India into India and Pakistan, right? Okay. So protection of interest of minorities. So post independence, it was said that there was lot of threat for minorities. So minorities includes Christians, Sikhs, Jains, Muslims, Parsis, and other sects. Okay. So what does it say? Protection of interest of minorities. So Article 19 provides that any section of citizens residing in any part of India, having a distinct language, script. So it also includes linguistic minorities, not only religious minorities, and cultural minorities also. What are the cultural minorities? These transgenders are a cultural minority, and also, they are a social minority actually. So even they form a section of minority. Even people with disability are a minority section. So people having distinct language, linguistic minority, script. Tribals have their own script, and also culture of their own, have the right to conserve the same. So they have the right to protect the same. So coming to the next right. So this is all about your protection of interest of minorities, that is based on language, script and culture. Okay. Moving to right of minorities to establish and administer educational institutions. So Syrian church case, Syrian college case has its link to right of minorities to establish and administer educational institutions. So minority institutions can acquire land to establish their educational institutions, and they can hire their own faculty. That is also allowed. However, recently the Supreme Court has said that in order to maintain the quality of education, the state can prescribe certain curriculum. Curriculum can be prescribed by the state in order to maintain quality of education in the minority education institutions. The case which I mentioned was specifically Malankara Syrian Catholic College. So Syrian College, I said you can simply write Syrian College because It's a big name to remember. So certain minority institutions seek recognition, certain seek funds. However, certain institutions neither seek recognition nor funds. So there are three categories of minority institutions which are protected under this act. So last but not the least, but the most important, right to constitutional remedies. Right to constitutional remedies. So this is the act which gives life to the entire fundamental rights. Without this right, the concept of fundamental right is dead. Okay. What does this right say? Constitutional remedies. So whenever fundamental rights are violated either by the state, majoritarily by the state, so the citizens can directly go to the Supreme Court under Article 32. Under what provision can they go to High Court when fundamental rights are violated? Article 226. Under Article 226, they can go directly to the High Courts to enforce their fundamental rights. So how does the Supreme Court enforce the fundamental rights? The Supreme Court has 5 instruments. There are 5 instruments to enforce the fundamental rights. However, before looking into the five instruments, we will see that Parliament can empower not only Supreme Court. Supreme Court is already empowered, and also the High Court. It can also empower even the subordinate courts to enforce these fundamental rights. So fundamental rights are enforced, that is, they are given life majorly by, so whenever state, suppose there is right to freedom of speech and expression. So this is one of the fundamental right. If the state says no, you cannot talk, your freedom of speech and expression is is prohibited. So then they send the police to curb your freedom of speech and expression. So what, you can directly go to Supreme Court and say that, see, the state has done this to me, so ensure me justice. So under Article 32, we can directly go to Supreme Court to enforce our fundamental rights. Likewise, to High Court. However, even the government can, that is the Parliament can empower even the subordinate courts. Subordinate court means district courts, taluk courts, JMFC courts. All those courts can be empowered to enforce fundamental rights. However, no such provision has been done. I said there are 5 instruments through which fundamental rights are enforced. What are these 5 instruments? It's called writs. So there are 5 types of writs. So are the writs available under High Court? Yes or no? So writs are available even by High Court. Okay. However, Supreme Court can issue the writs only for in these 5 aspects. However, High Court can issue writs for any other aspects also. That is, Supreme Court can issue writs only for enforcing fundamental rights. However, the High Courts can issue writs even for enforcing non-fundamental rights. Okay. So what are the writs? Habeas corpus. What is the most important writ? So what does habeas corpus say? So with respect to writs, there are certain points you can note down. One, Supreme Court can issue writs only for fundamental rights, which I already told. Supreme Court can issue a writ against a person or a government. So person, either an individual person or a government, and to the remedy under Article 32, that itself is a fundamental right. For that also writs can be issued. Okay. So habeas corpus. So what is habeas corpus? Habeas corpus means to have the body of. Suppose to have the body of. To have the body of. So suppose your friend or some relative is kidnapped or taken forcefully by individual, some private individual or police, you can go and file habeas corpus and say that we need that person here now. So then the court directs the police authorities to bring that person and present him or her in front of the court. So habeas corpus is very, very important with respect to state illegal detention and also private detention. Mandamus, the writ of mandamus. What does it say? However, mandamus, one caveat, it cannot be issued against private individuals but only government individuals. So, mandamus say we command. So, the Supreme Court commands the government to do certain activities. They say you are supposed to so government has to disperse certain funds. So, the court says you are supposed to disperse these funds. However, you have not done your duty. So, please do your duty. They don't say please and all. They just say we command, you have to do. So, no request. It's an order. Next comes prohibit. So, this is for doing the duty. This is for prohibiting from doing a duty. So, what does it say? We forbid. So, Supreme Court says, Supreme Court says that you are prohibited from doing this duty. However, this prohibition is available only in respect of judicial and quasi-judicial, that is subordinate courts and quasi-judicial. What are the quasi-judicial organs? Quasi-judicial organs means what? Your tribunals. National Green Tribunal is a quasi-judicial body. TRAI, Telecom Appellate, TDSAT, Telecom Dispute Appellate Tribunal is a quasi-judicial body. Likewise, there are many quasi-judicial, even when the district magistrate, district collector sits as a magistrate to settle certain disputes, he acts as a quasi-judicial body. So, the term quasi-judicial body is very, very important. Next comes the writ of certiorari. So, it says that to be certified. So, it is always issued by a higher court to lower court. That is, Supreme Court issues it to High Court, High Court issues it to lower court. So, why is this writ is issued? It's in order to, suppose a case is pending in a subordinate court. So, and High Court issues this writ, that is certiorari writ, to take the case out of the subordinate court and dispose it by itself. Likewise, Supreme Court can issue it to take the case out of High Court and dispose it by itself. So, this is the use of the writ of certiorari. Okay, next last comes the writ of quo warranto. What does quo warranto mean? Quo warranto. Under what eligibility? Under what authority? See, this is applicable in the case of public office. So, what are the public offices? Public offices means these public jobs, under public jobs, executive bodies. For example, CAG is a public office, Election Commission is a public office, Supreme Court is a public office, and so your CBI is a public office, Narcotics Control Bureau head is a public office. Likewise, there are so many public officers. So, even CM, Chief Minister is a public office. All the Council of Ministers are public office. So there are so many public offices. So if someone illegally holds the position of these public officers, then the court says, under what authority are you holding the charge there? What is your eligibility to hold that? So in that cases, this quo warranto is used. Okay. Okay, armed forces and fundamental rights. What are the armed forces in India? So we have Indian Army, Navy, Air Force, CISF, CRPF, BSF, ITBP, and so many military and paramilitary forces. Even the state police force is a armed forces. So is the fundamental rights which we discussed till now, is it equally applicable to all these armed forces? No. So armed forces has certain restrictions. All the fundamental rights are not applicable to them. It is being prohibited by certain acts. Navy Act is there, Air Force Act is there, and Army Act is there. Like State Police Act is also there. Next comes martial law and national emergency. Are they both the same? No. So martial law means imposition of military rule, whereas national emergency is imposition of emergency by the central authority. Who imposes it? It is the President of India who imposes the emergency. So there are certain differences. You can note it down. It says martial law says it affects only martial laws only affects the fundamental rights. So fundamental rights are not applicable in the areas of martial laws. However, national emergency not only affects the fundamental rights but various other things. It even affects the legislative business. That is, the state government cannot enact laws. So the parliament enacts laws based laws belonging to the state government. So it affects the central state relationships. Next comes it suspends the government and ordinary law courts. Martial laws, so local government, whether it is district government or state government, it is suspended, and even courts are also suspended. So they have their own courts and they are the martial law, they are the rulers. However, in national emergency, there is no local government is not suspended. Even courts are not suspended. So why is martial law imposed? In order to restore the broken law and order. Law and order issue is there, like in Nagaland, Northeast, Tripura, Mizoram, Manipur, Jammu and Kashmir, Jharkhand, Chhattisgarh. Some law and order issue is there. Martial law is imposed. However, this is imposed when they are based on three reasons: war, external aggression, and armed rebellion. These are the three criterions under which national emergency can be imposed. Under no other circumstances, national emergency can be imposed. Likewise, there are other differences also. So here this is applicable only for certain part of the country. It can be applied only for certain part. However, national emergency cannot be applied for specific part. So likewise, there are many other differences. Next comes martial law and fundamental rights. I said when martial law is imposed, fundamental rights are suspended. So when the martial law is imposed, when fundamental rights are suspended, this army, armed forces, the personnel of the armed forces, whatever they do, they are not liable for prosecution. Otherwise, in the normal times, if they violate your fundamental rights, they are liable for prosecution. However, during martial law, no prosecution. So they are protected. For example, your AFSPA, AFSPA, Armed Forces Special Provisions Act. So in that Armed Forces, any act, even killing a person, no prosecution. Okay, affecting certain fundamental rights. So certain fundamental rights are affected. Affected means given life. So given life by certain statutory and non-statutory acts. So what are those certain acts? So the parliament can give effect. That is, parliament can give effect to fundamental rights by framing laws. Can the state government frame such laws? No, because it has to be for entire India. The law has to be for entire India. If it is for state government, it is only for specific part of the country. However, this fundamental rights can be affected, given effect by national government, the parliament, so that only by the parliament, not by state legislature, so that there is uniformity of application. It is applied all over the country. Okay. Next comes the question of right to property. So earlier, Article 31, right to property was a fundamental right. That is, state cannot take away your property, immovable property, not movable property. Immovable property cannot be taken away by the state by forcefully. So you can go to court and get your property back. However, by constitutional amendment during the tenure of Sri Morarji Desai government, that is Article 44, state right to property was deleted. Now it is only a legal right under Article 300. Article 300A mentions that right to property is a legal right, not a fundamental right anymore. Okay. This is the present position of right to property. Exceptions. So there are certain exceptions to fundamental rights. I already told you what are the limitations of the fundamental rights. I mean, what are the checks and balances. So there are also exceptions to fundamental rights. So in case of, what is the first exception? In case of acquiring of estates, acquisition of estates. Estate means property. So in the case of acquisition of property, so fundamental rights only in certain specific cases. So acquisition of property by whom? By the government. So in those cases, estates which have the agricultural land. Agricultural land cannot be acquired by the government. So in case they acquire, they have to provide proper compensation. Even minority institutions, if they acquire, they have to provide proper compensation. Next comes the issue of saving of certain rights. If certain fundamental rights are violated by certain statutory acts, fundamental rights are violated by laws formed by the parliament or state government, that has been saved by which provision? That is, it has been saved from declaring as non-constitutional by ninth schedule of the constitution. Suppose they form a law. Most of the laws in this ninth schedule are land reform laws. So the government, the parliament or state legislature forms a law. So it violates the fundamental right. So if someone goes to court saying that, see, the government, the parliament has enacted this law which has violated my fundamental right. They have taken my property. So the court has the right to restore the property. However, what the Parliament did, certain land reform acts and certain other acts, they put it in the 9th schedule. So when they put these acts in the 9th schedule, so even if it violates the fundamental rights, person who is the victim cannot go to court asking the court to restore their property. That is one of the provision. Next comes saving of laws, giving effect to directive principles. Article 39C and 39B and 39C. So directive principles are principles followed by the government in order to formulate certain rules and also by legislatures to enact certain laws. So if directive principles, so in order to effect certain directive principles, they are majorly principles which are socially and economically empowering the society and citizens. In order to give effect to certain directive principles, fundamental rights can be violated. So what are these directive principles? One or two are there. One is prevention of concentration of wealth. So prevention of concentration of wealth is one, that is Article 39B, and the second one is concentration of wealth, and so both of them speak of prevention of on the concentration of wealth. Okay, both Article 39B and 39C. We will discuss it when we go to directive principle. And so first is accumulation of property, second is concentration of wealth. So in order to make laws against that, so concentration of wealth is a wrong thing, right? If the wealth is concentrated by a single person, what will the poor do? So as per the Oxfam report, top 1% of the world's population own how much percent of the wealth? 43%. So 1% of population, rich, 1% of the rich own 43% of the wealth. So in order to prevent that, certain laws can be framed. However, it is against right to equality. So if the victim goes to court, that law will be invalidated. So to prevent that, they have made a provision that 39B, 39C, if it comes, then it cannot be, violation of fundamental rights cannot be effected. So no grievance redressal in that particular case. Okay, next comes the criticism against fundamental rights. So what do they say? Excessive limitations. So this fundamental rights, that are actually not rights, however they are limitations or fundamental rights. Next is there are no social and economic rights, there are only political rights. Next is there is no clear-cut clarity, there are so many complexities in the fundamental rights. That is the third thing. Fourth thing is there is no permanency. The constitution can be amended. The constitution can be amended to change the fundamental rights. So that is one thing. Next is they are not sacrosanct. That is they are not permanent. They can be suspended. They can be suspended during emergency. Fundamental rights can be suspended during emergency. So what are the other criticisms? So preventive detention, which is made as a part of fundamental right. So there are a lot of criticisms, and there is no philosophy behind the fundamental rights. That itself is one of the criticism. Next is what is the significance. So there are certain significance. You can take down the they constitute the bedrock of the civil polity. Bedrock of the democratic system. Indian democracy rests on fundamental rights. Indian democracy rests on fundamental rights. So they provide moral protection, material and moral protection to the citizens. They serve as bulwark of individual liberty. So individual liberty cannot be violated by the government. So these are few of the significance. So there are lot of significance. So the fact that we are so free for thought, speech and expression, we can move wherever we want, we can reside wherever we want, we have the right to employment, we have the right to sleep, we have the right to privacy. So many things are because of fundamental rights. Without fundamental rights, life would have been really difficult. So as I said, there are certain articles with respect to fundamental rights which are very, very important. So the article starts from Article 12. From Article 12 till Article 32, it is very, very important. You have to know by heart. You have to know by heart each and every article so that you can reproduce it in the exam. Okay. So the most important part of fundamental rights is covered. Next, we will move towards directive principles of state policy. So what is directive principles? So we have to look at the word first. So the word says directive principles state policy. So it means directives to whom? Directives to the state. What state? Not the state government, the big state. S-T-A-T-E. I told you no, Article 12. So it is the directives to the state so that whatever policies you perform, whatever the policies you form or whatever acts you enact, whatever act you enact or whatever policies you form, it has to be based on these principles. So this is what is meant by directive principles. So it is part of part 4. So fundamental rights is part 3. However, directive principles is part 4. Very, very important. AFCAT direct question had come. Possibility of coming in civil services also. Okay. Where have we borrowed these directive principles from? So we have borrowed it from Irish Constitution. Irish Constitution means Constitution of Ireland. Where is Ireland? It is beside England. So you can have a look at it in the world map or the map of Europe. So what are the features of directive principles? So this resembles the instruments of instruction. Instruments of instruction to whom? So instrument of instructions enumerated in Government of India Act. Government of India Act, as I told yesterday in 1935, this act has certain instruments of instruction. Instruments of instruction. Certain instructions are given while forming the act. That instructions are called the instruments of instruction. So this resembles that, and also it resembles the objectives resolution. Objectives resolution it resembles, and also it involves social, economic and political. Fundamental rights only political. Directive principles include social principles, economic principles and political principles which has to be followed. So principles means values, ethics, ideals which has to be followed by the state or government in order to, or parliament while forming the policies. Okay. Next, directive principles are not justiciable. Justiciable means what? So even preamble is not justiciable. It means when fundamental rights are violated, as I said, under Article 232 and Article 226, you can go to court and ask the judge, sir or madam, my fundamental right is violated, please restore it. However, when directive principles are violated by the state or preamble is violated by the state, you cannot go to court and ask, please enforce it. Okay. Next comes what are the other features? These are certain of the features. So there is constitution doesn't give any classification of the fundamental rights. However, in the book, in your book, Lakshmikant has given classification of this directive principles into 4 things. One is social principles, Gandhian principles, liberal intellectual principles. So these are the 3 criterions and some new directive principles. What are the socialist principles? So what are the articles? I am going to first mention the articles from where the directive principles start. So directive principles start from article number 37. Article 37 till article 51. So here, as Article 12 mentions state, what is meant by state, even Article 36 also mentions the definition of state. So however, the directive principles start from the 37 to 51. Okay. So what are the directive principles? So first we will look at socialistic principles. What is meant by socialist principles? Why have we classified the directives, though no classification in the constitution? Why have we classified the directives into socialist, Gandhian and liberal intellectual? So first, why socialist principles? What is meant by it? Socialist principle means to enforce the social equality. Social means what? Caste, gender equality, caste equality, these and religious equality. So all these form the social dimension. Even transgender equality and even old age also, and even the physically disabled. So to ensure equality of all these principles come under socialist concept. So India starting in 1947 tried to be a socialist state. However, it peaked during the emergency and post-emergency. However, post 1991, liberalization, privatization and globalization, socialist principles have been diluted. So we are moving towards more and more liberal principles. So what are the socialist principles in constitution? So Article 38 says to promote the welfare of people by securing a social order permeated by justice, social, economic and political, to minimize inequalities in income, status, facilities and opportunities. So such a big thing, I will make it simple for you. First thing is, so first part is to promote social order. Social order is, if you promote it, that is a directive. So the government has to promote a order in the society. That is the first directive under Article 38. And it has to ensure justice. What type of justice? Justice, nyaya. So social justice, that is all sections of society are given justice. I told you what are the sections which come under the term social. And economic justice and political justice, that has to be ensured. Next in under Article 38, you have to minimize the inequalities. The state has to minimize inequalities in income, status, facilities. So this is Article 38. So next comes Article 39. So Article 39 the state has to secure, the state has to give what all to the citizens? Right to livelihood. Livelihood means job. So in 2016-17 there was a leak of report by National Statistics Organization which said that, what did it say? The unemployment rate in India is the highest in 45 years. So unemployment has become a runaway unemployment. So what is the present unemployment rate? It is around 6%. So certain facts you can use in the written part of the competitive exams, that is in civil services, the mains examination. Okay. Next is livelihood securing, then equal distribution of material resources. I told you 39B is equal distribution of resources, environmental resources, economic resources, everything, all the resources equally distributed. That is the second thing. Third is prevention of concentration of wealth, 39C, I have already told. Equal pay for equal work for men and women. Preservation of health of workers. Workers' health have to be protected and children's have to be protected. And last one is 39F, healthy development of children. So these are the directives, social directives for the state. Next is, I told you, legal aid for the poor. Free legal aid for the poor is 39A. That is also a socialist principle. Next is right to work. Right to work, to education and to public assistance in case of unemployment. Article 41, that is also a socialist principle. Right to work. If you don't have work, government has to give you work. Manrega. Right to education. Right to care in the age of, in old age and sickness. So Vayo Shresth Samman Yojana, Rashtriya Vayo Yojana, Vayo Vandana Yojana. So Indira Gandhi National Pension Yojana. So all these are an outcome of this directive principle. Next is for Article 42 says human conditions of work. You have to give human conditions at work and also maternity relief. So Maternity Benefit Act. So the length of paid leave was increased from 12 weeks to 24 or 28. Just check it out. Maybe it is 24 weeks of paid leave. Okay. Next is Article 43, right to secure a living wage. So you have the right to secure a living wage. So there is a concept of minimum wage. Minimum wage, food, shelter and clothing. However, living wage is more than that, which says right to health, right to good quality of education, right to decent condition of living, leisure and so many other things. Living wage, minimum wage concepts are different. So that is also ensured in this. And Article 43A, what does it speak? 43A says that workers can participate in the management of industries. So these trade unions, workers can manage the industries. So management board, workers should have 1 or 2 representation. So last is under social principle is Article 47. What does it say? So the government has to increase the health and nutrition. So that is why this National Nutrition Mission and Poshan Abhiyan. So it stems out of this article. Next we come to Gandhian principles. So I would like to tell it again. There is no such division in Constitution. This is done by Lakshmikant in order to easily remember. Okay. Next comes Article 40 under Gandhian principles. So village panchayats. So whatever you see, the 73rd and 74th constitutional amendment, Panchayati Raj, stems out of this article. Next comes Article 43, formation of cooperative societies, cottage industries. Cottage industries stem out of Article 43 and also management of them by cooperative basis. Next, cooperative societies, Article 43B. Recently, the Government of India formed Ministry of Cooperation, which is headed by, right now by whom? At the beginning, it was headed by Shri Amit Shah, our Honorable Home Minister. So, who is heading it now? Please check it out. Okay. Next comes your Article 43B. That is, I already told that. Next is Article 46. What is 46? 46 speaks about protection of deprived societies, deprived section of the society, that is scheduled caste, scheduled tribes and other sections. So you have to promote the educational and economic interest of SCs, STs and other deprived sections under Article 46. Next comes your Article 47, where intoxicants have to be prohibited. So Supreme Court few years back banned alcohol in the highways. So it stems out of this article. Gujarat, there is a prohibition, total prohibition. It comes out of Article 47. Next comes your Article 48, prevention of slaughter of cows. So Cow Protection Act, UP, Haryana, Rajasthan, wherever it is being formed. So it has legal basis in the support by the directive principles in Article 48. Okay. Next we have liberal intellectual principles. So liberal intellectual principles means, so these are most progressive and modern ideas in the directive principles. So we will look at some of those. So uniform civil code. Uniform civil code means what? So we have separate laws for Hindus, Muslims, Christians and others for marriages. Hindus have Hindu Marriage Act, Muslims have their own code, own act, and intercaste marriages have Special Marriages Act, and every religion has their own marriage and inheritance divorce act. So Uniform Civil Code says you have to bring in a common act. So UCC, very, very important, not yet enacted. Article 44, it's a liberal intellectual principle. Next comes Article 45. So right to education. So it's appendage. So every parent has to, so the state has to give. So what the state has to give? So the state have to give early childhood care and education until age 6. Until age 6. Till age 6, the government has to give free early child care education. New education policy, new curriculum. What is the division? 3 plus 5, 3 plus 4 plus 4 plus 2. What is the division? I forgot the division. Please look at the division. New education policy 2020 is very, very important. So the entire curriculum is divided, the entire progress is divided as 3 plus 4 plus 4 plus 2 or something like that. Primary education, secondary education, higher education, higher secondary education. 3 plus 4 plus 4 plus 2 or something along those lines. So that is where your early childhood education. So next, organizing agriculture and animal husbandry on scientific lines. Article 48. 48A, protection of environment. All your Environmental Act. National Action Plan on Climate Change 2008 stems from this. National Wildlife Action Plan 2016 stems from this. Project Tiger, Project Elephant stems from this. Okay. Next is to protect monuments, places and objects of historical importance. So historical importance. So your Amsar Act. What is Amsar Act? Ancient monuments and Ancient Architecture Protection Act. It has its origin in Article 49. So next we have Article 50, separation of judiciary and executive. Judiciary and executive separation means what? Earlier, before Enactment of Criminal Procedure Code, CRPC. So the district magistrate, DC, used to be a judge also. He used to dispose criminal cases also. However, after Criminal Procedure Code, CRPC was enacted. After CRPC was enacted, so the judicial function is taken out of the collector and given to judicial magistrate. So that is Article 50. Next is Article 51, which says protect international peace and security. International peace and security. Your international peacekeeping force, IPKF, India's support to this, and India's support to non-alignment movement, NAM, India's support to nuclear denuclearization, India's support to non-proliferation, and all those things stems out of this. Okay. So next is new directives. We have added certain new directives. What are the new directives? To Article 39, healthy development of children, was added during 42nd Amendment Act under the tenure of Srimati Indira Gandhi ji. Emergency. And Article 39A, equal justice, free legal aid, that was also added during 42nd Act. And promotion of allowing workers to participate in the management of industry, 43A during 42nd Act. Then 42nd Amendment Act. Then we have environmental protection, I told, 48A during 42nd Amendment Act. Why then? Because 1972 there was Stockholm Environment Conference. Stockholm Environment Conference 1972. So then only we will see various Air Act, Water Protection Act, Water Cess Act, so many things gets started in 1974. So environmental revolution in India. Okay. So next we have, so later on we have 21A, Article 21A was added, right to education, during 2002 Constitutional Amendment, and 97th Amendment Act 2011 added 43B. 43B, what does it say? Promotion of cooperative societies. So cooperative societies were given constitutional backing. Next, we will discuss enforcement and implementation. So enforcement and implementation. So how do we enforce? So the government can make statutory laws to implement the directive principles. So what are the, and for how is it enforced and implemented? So there are various initiatives taken by the governments at various times. So some of the initiatives are, the Planning Commission was established in 1950. Niti Aayog was established. Then we have Land Reform Acts were passed by various state governments, and we have Minimum Wages Act, Child Labour Protection Act, and we have Maternity Benefit Act, and we have to provide free legal aid, we have Legal Services Authority Act 1987, and we have Khadi and Village Industries Board were formed, and so this Cow Protection Act being formed, being enacted by various state governments, and also prohibition of alcohol, and we have this Community Development Program, Wildlife Protection Act 1972, Wildlife Protection Act, Forest Conservation Act, and various other things were enacted. Even for example, I told Amasar Act was enacted, and EWS reservation, OBC reservation, SC/ST reservation, everything is stems out of directive principles. So there is so every act, every policy which is made by government can be linked to the directive principles directly or indirectly, because this is the blueprint or framework for the government to frame its policy or acts. Okay. Next, so we have seen enforcement and implementation. Okay, what is the significance? You earned utility and significance. Okay, we'll discuss it later. First, we will see criticism. So, first criticism is there is no legal force. It cannot be legally implemented. Next criticism is they are illogically arranged. So, Lakshmikant arranges it logically. So, in the constitution, they are illogically arranged. So, next is most of them are conservative. The criticism is most of them are conservative. And fourth criticism is it gives rise to constitutional conflict. What is a constitutional conflict? There is a conflict between fundamental rights and directive principles. Okay. So, coming to utility. Does it have any utility? So, even in the Constitutional Assembly, there was so much debate whether to include directive principles in the Constitution. So, certain section said, yes, we have to include it because it acts like a lighthouse or a beacon light for the government to proceed. However, other section said, no, we don't need it because it's a superfluous. So, it curbs the freedom of the government. However, it does have certain utility. So, what are the utility? So, it facilitates the stability and continuity of policies. Every government has to adhere to directive principles. Even Supreme Court can make use of directive principles while deciding the legality. Certain acts can be treated with lenience when it says that it gives rise to or it gives effect to certain directive principles. So, it does have utility in the larger framework of Indian polity. So, next is the position with respect to fundamental rights. This is the most important section. So, which is the act? Which is the case? Minerva Mills case. So, differences between fundamental rights and directive principles. So, the fundamental rights prohibit the state to do certain things. However, this is directive principles allow or push the state to do positive things. Next is fundamental rights are justiciable, whereas directive principles are non-just. That is, the court cannot enforce this. So, they are political. These are economic and social. That is, if DPSPs are economic and social. So, the fundamental rights promote individual welfare, whereas this promotes societal welfare. Okay. So, these are certain differences between the fundamental rights and directive principles. So, there was a conflict. So, the court said, so what used to happen to give rise to give effect to certain directive principles? Every time government used to tweak the fundamental rights. So, it may be Shankari Prasad case, Champakam Dorairajan case, Gopalan case. All these cases, important cases, you should know. So, in Lakshmikant, important cases, certain section is given. So, please keep revising it. So, in Gopalan case and even in case 1 and the Bharti case. So, ultimately, in Minerva Mills case, what the court said, so what the government used to do to give effect to these directive principles, fundamental rights were always tweaked by constitutional amendment. So, the court took a lenient view in case 1 and the Bharti case and said, okay, to give effect to certain directive principles, you can tweak the fundamental rights. However, what the government did, so it changed it to saying that to give effect to all directive principles, we can tweak any fundamental rights. That is what the constitutional amendment done by the government. So, Again, case was filed in Supreme Court, and Supreme Court said, no, only few directive principles can be affected by tweaking the constitution. Not all fundamental rights can be violated for giving effect to the directive principles. That is when emerges the concept of basic structure in Keshwananda Bharati case, 1973. Yesterday also I spoke about this important case. Then in Minerva Mills case, 1980 Minerva Mills case, the Supreme Court says that Indian Constitution is formed on the bedrock of fundamental rights and directive principles. So both are equal. It's like two wheels of a cycle. So without one wheel moving, another wheel cannot, in a single wheel we cannot move forward. So fundamental rights and directive principles both are equally important. So this is all about your fundamental rights. As I tell every time, I will tell you the important articles at the end of each class. That is, now the article I have mentioned here, 37 to 51, about the directive principles. Okay. Now, as a last section, we will speak about the fundamental duties. Okay. This is your fundamental duties. So, what do you mean by fundamental duties? Fundamental means basic. It is fundamental to your existence. It is necessary to your existence, quintessential for your existence. So, fundamental duties. So, did the original constitution have fundamental duties in it? No. Original constitution did not have fundamental duties in it. When was it included in the constitution? So, it was included in 1976, 42nd Amendment Act, mini constitution, enacted during emergency by whom? So, the Iron Lady of India, Srimati Indira Gandhi ji, one of the blunders in Indian political history. What is the blunder? It is the emergency. So, open for criticism from all possible angles. So, what is the origin of fundamental duties? We have taken the fundamental duties from which constitution? Fundamental duties were taken from USSR, erstwhile USSR. So, which country is now USSR? Russia forms the major part. Soviet Union, USSR is Soviet Union. That is where we have taken the fundamental duties from. So, also it has the origin in, it has an indigenous origin. So, we have Swaran Singh Committee. Swaran Singh Committee was enacted by it was formed by Srimati Indira Gandhi ji, and it gave a series of recommendations. So, those recommendations found its concrete form in the form of fundamental duties. So, fundamental duties form part of 4A. So, it is appended to part 4. Part 4, it is appended. So, what is part 4? It is directive principles. Part 4A is your fundamental duties. Part 3 is your fundamental rights. So, parts are very, very important. So, what is the article number for fundamental duties? There is only one article. That article number is Article 51A. Very, very important. So, what are the fundamental duties? I am going to read out the fundamental duties for you. So, these are the duties which we as a citizen. So, what was the recommendation of the Swaran Singh Committee? So, during emergency, there was no responsibility on the part of citizens. So citizens have to behave in order to reap the benefits of rights. They have to perform certain duties. So what are the duties? So I am going to read out the duties in the Constitution: to abide by the Constitution and respect the national institutions. So national flag and national anthem is your first duty. To cherish the noble ideals of national struggle and freedom is your second duty. The third duty is to protect sovereignty and unity and integrity of India is your third duty. To defend the country and render national service. So rendering national service when called upon is your fourth duty. Fifth duty is to promote harmony and spirit of common brotherhood and religious, linguistic, and regional and sectional diversities. Transcending all these boundaries, if you promote harmony among Indians, that is also a fundamental duty. To preserve the rich heritage. If you preserve the rich heritage of India, that is also a fundamental duty. So to improve the natural environment is your fundamental duty. And also to develop scientific temper, humanism is also fundamental duty. To object from violence and destruction of public property is your fundamental duty. To strive for excellence, to achieve excellence in all fields. You clear IAS exam, so that is achieving excellence. So you have abided by the fundamental duty. And also to provide opportunities of education. So this is important. This was added by 2002 Act, 2002 Constitutional Amendment Act. So every parent has to educate his children up to from age 6 to age 14. It is a fundamental duty. So I have told the list of fundamental duties. Surprisingly, right to vote is not a fundamental duty. Right to pay taxes is also not a fundamental duty. So those are not included. So what are the features? So like directive principles, fundamental duties are also not enforceable. They cannot be enforced, legally enforced. Most of them are moral duties. So that is also moral duty. So they refer to the values we Indians cherish as a group of citizens. So fundamental duties does not extend to everyone. It is only limited to Indian citizens. Foreigners need not follow it. So there are also certain criticisms. So criticism of fundamental duties. So one is it is not legally enforceable. That is one criticism, and most of them are called as moral aspirations. They are not on ground realities. That is another criticism. And also another criticism is right to vote, right to tax, and important things are not included. And also they form a subcategory of fundamental rights. So it doesn't have as importance as fundamental rights. That is also a criticism. Okay. Next comes what is the significance of these fundamental duties. So it reminds us of our duties while enjoying our rights, as I said. Then also they act as warning to anti-national active elements like terrorists and all. So they act as a warning. Then they act as an inspiration, source of inspiration to so many people. So we every day morning we wake up and sing national anthem. It inspires the patriotism within us. So that is one of the significance. Okay. Next, last but not the least. So these fundamental duties were reviewed by Verma Committee, Justice Verma Committee. Very, very important. So they said whether fundamental duties should continue being a part of the Constitution. They said yes, it has to continue. And they said Prevention of National Honors Act. So many acts derive their source in the fundamental duties. One of the act is Prevention of Insults to National Honors Act. Even this Unlawful Activities Prevention Act, Representation of People Act, Wildlife Protection Act have their source in the fundamental duties. So this concludes your chapter on fundamental duties. So this is your article 4A. So most of the things, concepts is taken out from Lakshmikant, and I am going to add current affairs here and there. Why I am not doing anything extra or special? You might expect me to do something extraordinary in polity. However, I am here to make you fetch marks, not to show my proficiency or panditya. Okay? So, if you just study Lakshmikant, that is more than sufficient. That is what I am going to teach. So, I am going to teach only from Lakshmikant, because that is where questions come from, and that is the sole source from rank 1 to rank 800 in UPSC or State Civil Services examination. I don't want to mesmerize you by telling so many alien foreign concepts, so which might not be required to you for the exams. You will feel happy that I told so many things which is not available anywhere, not available in the book. However, those things don't come in the exam. What comes in the exam is what is there in Lakshmikant. So that is why I limit my classes only to the concepts in Lakshmikant, and also here and there I am going to clarify the concepts, and also here and there I am going to add current affairs and my knowledge to make you understand the concepts clearly. So this is the end of our second class, and thank you for your patience in listening the class. I hope you found it very, very useful, and all the concepts are really important what we discussed today. So have a nice time. Take care of yourself. Thank you.